Make your dog owner on vibrate, peeing or drinking at any store, but 4 to 5, increase it by reports, have one. He's gonna go over all the paperwork, so you don't have to worry about filling it out right now. Okay. All rise. Time for one to session, or because Terrence don't preside.
You may be seated. Good morning, ladies and gentlemen. I'd like to welcome you to the County Court at London 2. My name is Judge Terrence Holmes. I'm presiding judge here in County Court at London 2. This morning, you're here for what is called an arraignment. And what an arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months, so a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years, to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of capital murder, which is the highest felony, if they're convicted, the range of minimum is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type punishment because, as I mentioned to you earlier, your case is a misdemeanor case. Misdemeanors are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. A person is convicted of a Class C misdemeanor. The range of punishment is by fine only, and the fine cannot be above or cannot exceed $500. Now, Class C misdemeanors are cases that start in the JP court or the city court. For example, speeding, not having your seatbelt on, or has an expired license sticker. Those are considered Class C misdemeanors. They come to this court when the person is convicted or plead guilty, no county tax, or is convicted by a judge or jury in the JP court or the city court, and then they appeal their case. In essence, they get a whole new trial. It comes to this court, the punishment range stays the same. And the punishment range, as I mentioned to you earlier, is a fine, and the fine cannot exceed $500. Now, the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and the fine. Now, the highest misdemeanor is a Class A misdemeanor, and the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such jail time and the fine. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. With that type of probation, that just simply means that you will not have a conviction on your record. And if you successfully complete the probation, your case will be dismissed. It will not result in a conviction on your record. And you may qualify for a non-disclosure, whereby your record will be sealed to the general public. Now, the next type of probation is called adjudicated probation. We had unadjudicated probation, and now we have adjudicated probation. The difference between the two is with adjudicated probation, it does result in a conviction on the record. However, there is something that is called judicial clemency, whereby the judge can set your conviction aside. You will no longer have a conviction on your record, similar to a dinner party. Similar, but it's not the same. But with the judicial clemency, in order to qualify, three things has to happen. One, you have to successfully complete probation. Two, there cannot be any more time left on the probation. And three, you have to be successfully discharged off of the probation by the probation office. If those three things happen, then the court has the discretion to grant you judicial clemency. Now, if you get a subsequent conviction, and that is, if you get another conviction later on, after you have received judicial clemency for your case, then the case that you received judicial clemency on can be resurrected. It can be brought back up, and it can be revived. It can be used against you. And if you try to get a license with Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Okay, now, everyone here for arraignment, you should have a clipboard. Who does not have a clipboard? Okay, everybody have a clipboard. Okay, now, I'm going to go over that clipboard with you. Now, there should be a little short page that, don't worry about that. The first page that I want to go over is the page that is titled Judge's Explanation of Rights to Defendants Without Attorney. It looks like this. Right? Should be the first page on there. Looks like this here. Okay? Now, I will constantly refer back and forth to this page. Everyone, before you leave here today, you will make a choice on this document you're going to sign the date. But okay, the document is titled Judge's Explanation of Rights to Defendants Without Attorney. It states that as a defendant in a criminal case, you have three options. Three options regarding your right to have an attorney. That's what he's talking about. And it says, number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first sentence under number three states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. The next one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first sign a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. The financial, now this is only for people who will be applying for a court-appointed attorney. If you are not applying for a court-appointed attorney, you don't have to listen to what I'm getting ready to say. But if you apply, if you think that you like to apply for a court-appointed attorney, then you would have to read and sign this first document that's titled Jefferson County Affidavit of Injury. It's a 3-page document on the clipboard. All right. You read and fill out the first page, and then you'll go to the second page, and where it says at the top, defendant's oath, you fill out the top portion. Okay? You fill out this top portion. And you have to fill out the middle portion that is titled unsworn declaration by defendant. Okay? All right, now going back to the first document, judge's explanation of rights to defendants without attorney. There is a third sentence, and this sentence is for individuals who will be representing themselves. For example, when you have a right to represent yourself, if you like to represent yourself. That is, you're waiving your right to an attorney or giving up your right to have an attorney, and you desire to represent yourself. And just like an attorney would be able to talk to the district attorney or assistant criminal district attorneys about your case, you will be able to do that because you are your own attorney. Now, we have some assistant criminal district attorneys here in court. Right now, we have two. But we also have Mr. Williams, he's not in right now, but you'll have an opportunity, that's Mr. Williams right there. So you'll have an opportunity to talk to one of the three prosecutors about your case, if you represent yourself. But before you're allowed to do that, this paragraph states that you may not speak to the prosecutor. The prosecutor is assistant criminal district attorney, unless you first sign a written waiver of your right to be represented by an attorney. So the written waiver is a one-page document that is titled, and it looks like this, that's titled Waiver of Counsel for purposes of dealing with guilty plea or proceeding to trial. This is only for people who will be representing themselves. If you're not representing yourself, you don't have to worry about signing this form. What you would do for those individuals who will be representing themselves, you would have to read this entire document, and then you assign what it says defendant and dated today's date. Okay. Now, the next paragraph is for individuals who will be representing themselves. The state, be aware that the dangers and disadvantages of self-representation, waiving your right to an attorney and representing yourself, may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. And the last sentence, before we get to the very bottom, it states, this is for individuals who are representing themselves. It states that if you're representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So for example, so let's say you represent yourself. Let's say you would like to be given a probation on your case. And you talk to the prosecutor, and the prosecutor say, well, we're gonna give you a fine. Okay? And you say, well, I don't want a fine, I want probation. Then you say, well, judge, I like to either see if I could if I qualify for a court-appointed attorney, or if you like to hire your own attorney, you can hire your own attorney. So at that point, you can change your mind at any point. That's what this sentence says. It says that if you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court, requesting counsel from the court, saying that you asking for an attorney to be appointed to represent you. But you also, if you decide that you would like to hire your own attorney, if you can do that as well. Okay. All right. Now, at the bottom of this document, it says defendant's choice. Mark initials next to only one choice. Now, everyone here is going to make a choice, one of the 5 choices. All right. If you would like to hire your own attorney, then you'll place your initials on the first line to the left. And then you'll sign where it says defendant, you dated today's date, May 19th, And then you'll stop, and this is the only form that you would have to sign. If you have already hired an attorney, then you place your initials on the second line to the left, and the name of the attorney on the line to the right. Okay? It's right here, on the line to the right. You'll sign and date it, and then you'll stop. And this is the only form that you would have to sign. If you'd like to apply for a court-appointed attorney, you would have to place your initials on the third line on this document, sign where it says defendant, dated today's date, and then you'll go to the document that is titled affidavit, Jefferson County affidavit. It's just, you have to fill out the first page, and then you go to the second page, fill out the top portion that's titled defendant's oath, and we fill out the portion that is titled unsworn declaration by defendant. And then you'll stop. If you have already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left at the bottom, the name of the attorney on the line to the right, and you will sign and date it, and then you'll stop. And this is the only form that you would have to sign. If you would like to represent yourself, then you would have to place your initials on the fifth line at the bottom, sign and date today's date, and then you'll sign the form that is titled waiver of counsel for purposes of entering a guilty plea or proceeding for trial. You'll read this, sign it, date it, and then you'll stop. Do we have any questions?
Yeah,
Yes.
I have a court-appointed lawyer for a felony offense. Can I use that rule here?
No, each court has to appoint an attorney. So you can apply if you go court-appointed attorney here. Okay? Next.
Are there a court appointed attorney? Will I have to come back another day, or will it all be done today?
No, your attorney will be appointed today, but your case is not being disposed of.
So I'll have to come another day for that.
Yes, because the attorney has to. We have to get attorney notice, notify the attorney that he or she has been appointed on the case. And then the attorney has to get with the district attorney's office to get what is called discovery, and I'll explain what discovery is a little later on. And an offer, and then the attorney will have to do an investigation, the attorney will visit with you, any witnesses, etc. And then the case is usually reset for what is called an announcement, where he or she would come to court and announce whether or not they want a trial, or whether or not they're going to end the plea. All right, yes,
What if you want this plead guilty?
you can do that. You can be representing yourself. At the bottom, where you place your initial on the fifth line to the left. And you'll sign and date it. And then you'll fill out this form that is titled waiver of counsel for purposes of entering a guilty plea or proceeding a trial. Sign and date it. And then you'll have an opportunity to talk to one of the prosecutors. Okay? Okay, anybody else have a question? Oh, yes.
My question was, I'm sorry, I just think I wasn't aware of.
Okay. Okay, I mean, this is, so you're on the docket for that charge, right? You were here for that charge, that's what you're saying? Okay. Okay, so,
Would it be smarter for me to get a court?
well, I can't give you any advice. Okay, I can't give you any legal advice. But the only thing I can give you right now is just tell you what your options are. Okay? You can, make a decision as to, what you want to do. Okay, anybody else? All right, next we have, I need to go over. Okay, you have a right, not only have an attorney, But you also have a right to, if you enter a plea of, well, let's do this. There are three pleas, one of three pleas that you can enter. You can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or contesting those charges. Now, you have a right to have a trial. You have a right to have what is called a trial by jury. When a young lady is sitting in that area with those 12 seats, we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. 6 because we're in a county court. It'd be 12 if you was in a district, but this is county court. And so 6 citizens will be selected to serve as jurors on your case. They can, they'll listen to all of the evidence that's presented by the state, by the defense. They'll listen to the oral arguments of the state and the defense. They will go back into the jury room to deliberate, and they can do, they'll deliberate, and they can either find you not guilty or guilty of the charges. You can waive or give up the right to have a jury trial. By waiving and giving up the right to have a jury trial, what that means is you will not be having a trial by jury. Now, you still can have a trial. It is called a bench trial. And what a bench trial is, it's a trial by judge. The reason why they call it a bench trial because the judge sits on the bench. So the judge will be the judge and the jury in the case. The judge will listen to all the evidence that's presented by the state and the defense. The judge will listen to the arguments of the state and the defense. The judge will apply the facts of the law. And then the judge will decide to find you either not guilty or guilty. Now, you can waive or give up the right to have a bench trial as well. Now, if you're waiving your right for a jury trial or bench trial, obviously, you're saying that, hey, I'm entering a plea of either guilty or no contest. Now, if you enter a plea of guilty or no contest, you or your attorney would have an opportunity to talk to the the prosecutors of the district attorney's office to see if y'all can work out what is called a plea bargaining agreement. It's just it's a settlement case. Now, if you are able to work out a plea bargaining agreement, we call that an agreed plea bargaining agreement. And in essence, you have agreed to it. State and the defense have come to an agreement with a plea bargaining agreement. It goes before the judge. The judge can do one or two things. The judge can either accept or reject that agreement. Now, if the judge rejects the agreement that you entered into or that you made with the state, then you can take your plea back. And that's when you can withdraw your plea. For example, let's say you wanted probation. The state is offering probation. It goes before the judge. And the judge said, well, I'm rejecting the plea. I'm not following you. You can tell him, say, well, judge, I take my plea back. I'm not entering a plea of guilty or no contest. Since you're not agreeing to accept the plea bargaining agreement, you have a right to do that. All right. Now, at that point, now, if you decide to go to the court, to the judge on what is called an unagreed plea bargaining agreement, what that means is you haven't reached an agreement, but you want the judge to decide what the punishment will be. And we call that an unagreed plea bargaining agreement. Judge will assess punishment anywhere within the punishment range. Now, you had your hand up?
Yeah, so I got failure to ID.
Good, thank you.
Yeah, and I did the time. My bond was like 500, which was like $100. You know, and I just did the time. It was like a week or something like that. So I'm thinking everything's good. I get out. I wasn't working at the time, so I was like, might as well just sit it out. I get out. I get stopped for a tail light, and I go in.
Oh, you probably
They didn't give me no paperwork telling me that I had to go to court or anything.
Yeah,
So
okay.
I got out.
No, it's accusation.
Yeah, that's
Yeah,
probably
Yeah,
what,
that's-
it probably was like what she said, it was, they call it accusation, they let you
I know
out.
that.
Nah, it wasn't an accusation because they kicked my case off.
Yeah, that's what I'm saying, though. Like,
Oh,
I don't give you no paperwork to let you know something.
From who though? You're not gonna.
Oh, you talking about the jail?
Yeah.
They're not gonna let you know.
So why they don't do that though?
They don't know that the DA picks it up.
Yeah, that's what.
Once you're out on the 3-day accusation.
I lose my job,
No, we
they
bonded.
my truck and everything.
We bonded out, we didn't get that.
Either way, bond out, already.
No, I did the
Stay
time.
there 3 days.
I was like, I'm not.
Yeah, but John, okay, let me just say, okay, you think you did the time.
Yeah.
Yeah, it's not even.
No, this is what happens. When you come to court, you get a judgment in court. They can't tell you at the jail that you served your time, it doesn't work like that. You have to come to court, and that's why you're here. So your first appearance in court, which is today, is the arraignment. Okay, and so that's why you're here. That's part of the process.
So basically, you're here fighting the charges.
Right, this is part of the process, okay? Okay, now, let's see. Okay, I talked about an unagreed plea bargain. Now, the other thing is, you have a right to have, witnesses that come to court. Witnesses sit in that chair right there with the microphone, we call that the witness stand. And what witnesses do, they can either testify for you or against you. If you have a lawyer, the lawyer can ask some questions, you can represent yourself, you can ask some questions. We either call it direct examination or cross-examination. Now, you can waive or give up the right to have witnesses that come to court. If you waive or give up the right to have witnesses that come to court, that simply means that you will not be calling witnesses. But it does not mean that the state will not be calling witnesses, because the state will be calling witnesses in your case. Now, you also have a Fifth Amendment right against self-incrimination. What that means is you have a right to remain silent. You have a right not to testify. In your case, the state, the defense, the state, the government, the DA's office cannot force you to call you to the witness stand and testify if you invoke or exercise your Fifth Amendment right against self-incrimination. Now, I know a lot of times we watch television shows like Law and Order, and we see a television lawyer go up to the witness stand and ask the witness a question, and the witness says, "I'll take the fifth." What the witness is saying is that I'm exercising my Fifth Amendment right against self-incrimination. I'm not saying it. Now, I always say this, it really makes sense if you think about it, so you have that right. And the reason why it makes sense is because, first of all, the state has the burden of proof. What that means is the state has the burden to prove that you committed the offense. All right, beyond a reasonable doubt. Now, you don't have to prove yourself guilty, right? You don't have to prove yourself guilty. And so that's why you have the Fifth Amendment right against self-incrimination. Now, the other thing is, you have a right to have discovery. And what discovery is, you have a right to see the evidence. The state has a file on your case. You have a right to have access to the evidence that's in the file. Okay, you or your attorney. If you represent yourself, you have access. The attorney has access. And you have a right to see your statement, witness statements, police reports, lab reports. Your right to see video recordings, photos. Your right to listen to audio recordings, see documents or instruments, whatever evidence that the state has, you have a right to have access to that evidence. Okay? Now, you can waive or give up a right to have discovery. If you waive or give up a right to have discovery, that simply means that you will not be having access to the evidence. Now, everyone that's here today, you hear, you've been charged, been filed, you've been arrested, you've been booked in the county jail, you're bonded out of the county jail, you're either out of jail on what is called a cash bond, you're out of jail on a surety bond, or you're out of jail on a PRR bond or personal recourse bond, which means that you did not have to pay anything to get out of jail. You were released under your own personal recognizances. I say that to say this. Every day that you spent in jail can be used as credit toward your punishment. So for example, let's say you spent 5 days in jail. And, well, let me back up. The operative word is every day. Let's say, for example, you were booked into jail at 11:59 PM last night. And then 2 minutes later, at 12:01, you booked out. That's 2 days. Why is 2 days? Because it's 2 different days. One day was Monday. 2 minutes later, it was Tuesday. So you get credit for 2 days. All right. So let's say you spent 5 days in jail. And let's say you talk to the prosecutor and they offer you 5 days in jail. Guess what? You don't have to do no more time in jail. Why? You'll be given credit for the time that you have already served. Now, if the state is offering 7 days and you spent 5 days in jail, you get credit for the 5. We subtract 5 from the 7, it leaves 2. You would have to serve 2 days in jail. Now, let's say the state is offering fine and court costs in this case. Now, for every day that you spent in jail, you get credit $100 per day for every day that you spend in jail that will go toward your fine and your court costs. So for example, let's say you spent 5 days in jail. That's $500 that can be credited towards your fine and court costs. So if the state is offering fine and court costs of $500, that means you don't have to spend anything because you already have $500 and the $500 will be taxed and retired. And so it's already paid for. You don't have to pay. Now, if the state is offering $700, but you spend 5 days in jail, which is $500, we subtract 500 from the 700, that leaves 200. You have to pay that on the day that your case is taken care of. Now, if you cannot pay it, no problem. Why? Because we can put you on a payment plan where you can pay it off in small monthly installments. But let's say, even if we put you on a payment plan, you couldn't pay it off. No problem. Because we can convert the fine and court costs to community service. And for every 1 hour of community service that you perform at a nonprofit organization in Jefferson County, $12.50 will go toward the payment of your fine and court costs. So for example, in our scenario, if you work 8 hours in one day, or an 8-hour day, that's $100 that will be going toward your fine and court costs. So in our scenario, you work 2 days, that's $200. Your fine and court cost is paid off. Okay? Now, Jefferson County District Attorney's Office has a program. Let's say you haven't been in trouble before. This is your first time getting cases filed against you. You got 1 or more cases filed against you, first time. Well, the District Attorney's Office has a program that is called pretrial diversion, where if you get in the program, complete the program, they will dismiss the case and you can get it wiped off of your record. It's called expunction. Okay? Now, in order to qualify for the program, 3 things has to happen. 1, it has to be your first time getting 1 or more cases. 2, you have to have an attorney. The attorney could be court appointed. Don't have to be hired, it could be court appointed. And 3, it cannot be a foreign offense involving unlawful carry of a weapon or resisting arrest. Okay? But for all other cases, if you qualify, you can get into the program, you complete the program, they dismiss the case, and you can get it wiped off your record, like it never happened. All right. Now, if you're a veteran of any one of the branches of the United States military, the District Attorney's Office has another program that is called Veterans Court. It's for veterans only. Only thing you have to do to get into the program is you're a veteran of any one of the branches of the United States military. And with that program, you get into the program, you complete the program, they dismiss the case, and you can get that. You get I think you get a non-disclosure or a expunction on it. Okay? Now, this court, County Court at Number 2, has a program that is called the CSI program. CSI stands for Community Safety Initiative. And with that program, that's a program that God led me to start in March of 2019, within the first 100 days of taking office. And that program is designed to address the issue of what is called recidivism. Recidivism means people commit crimes over and over. And so with that program, we have partnerships. One of the partnerships that we have is with Spinnertop. We have some folks here from Spinnertop. They want to come to you in a few minutes and tell you a little bit more about the program. But Spinnertop is our local mental health center in the Southeast Texas region. And with Spinnertop, they have the expertise to address individuals who have mental health issues. Now, you do not have to be incompetent or insane to participate in the program. You could just merely suffer from anxiety, depression, or any other host of mental illnesses. And they have the expertise, the counselors, mental health officers, and facilities to address your mental health needs. Now, if you have issues with drugs and alcohol, well, Spinnertop has a drug and alcohol recovery program that is known as ATAR. It's ATAR. It's an acronym that stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OZAR. OZAR, or SAR, is an acronym that stands for Outreach, Screening, and Recovery, or referral speech. Now, both of those programs are drug and alcohol recovery programs. And what they would do, they would have a screening. They would do an assessment to determine what your drug and alcohol issues are, and then they could develop a treatment plan for either outpatient or inpatient treatment. Now, with Spinnertop, what Spinnertop will do for the mental health program, they will do in a private interview. It could either be in our jury room, it could be a death facility, by telephone, or it could be by text, depending on whichever is comfortable for you. They will do an assessment to determine what your mental health needs are, and they will develop a treatment plan to address your mental health needs. They could either be an outpatient or inpatient treatment, depending on your mental health needs. If you're unemployed or if you're looking for a better job, well, we have a partnership with the Golden Triangle Department Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE is an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of the areas that you choose, they will help you to get a job in the area that you're trained in. Now, if you haven't graduated from high school, if you do not have your GED, well, they have CICE, as well as Spinnertop has a GED program, which you can receive your graduate equivalency diploma, your GED. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this quote, we don't just give time, we take our time. That is, we do not just arrest the problem, we address the problem. We believe if we address the problem, we produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at law number 2 in Jefferson County, Texas, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we are trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, then we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned to you, and you're interested in getting on the road to living your best life, just let us know. And we can give you the brochures where you and the contact with people that can help you to get on the road to live your best life. Now, at this time, we have some folks from Spinnertop. They're going to come to you right now and just tell you a little bit more about the program that Spinnertop has to offer.
Thank you.
Okay.
Good morning, everybody.
I'm definitely functional with the County Sheriff Department. I'm also the liaison officer with Stone Top. My reason for being here is to somewhat give you an introduction to the Stone Top program. This is my partner here, Mr. Clemens. He's a qualified mental health professional. And, if you become a Stone Top, client, she'll be the one that you've been speaking with private. The Stone Top program is not acceptable. Folks who have mental issues, it could be also offered to you as a, substance abuse or you can find a job, place to stay. We're trying to explain all that to you in this beginning. If you become a Stone Top client, myself, two of the deputy, will be the transportation for you if you need transportation. You ride to your doctor's appointment or intake appointments at home, for the ones that need. Okay. This one's on you.
Good morning, guys. Hi, if people here staying in the restaurants, we also provide rides. We can assist with residential. We also have our mental collections. We have veteran as well. Within the mental collections, we have counselors available. We provide services for education or therapy. With our veteran services, they assist with you getting benefits as needed. As far as the substance abuse, we have classes on campus, AA, private, it's totally optional for you guys to fill out these forms. But if you would like to speak with us one-on-one, we're here today, or you can text or email phone call, whichever is more better for you. Any questions?
Good, also let me say this, if you do decide to speak with Ms. McClain, it's all private. The information will not be leaked out anywhere. It belong. Victim so. Sadly, we'll discuss anything that's, it's private.
Okay. Thank you, Deputy Butler, Tanya. So now, ladies and gentlemen, the paperwork that you have on that clipboard, we're gonna give you the opportunity to finish it, and then we're going to pick it back up from you, and we're gonna put you in one of three categories. One category is if you would like to hire your own attorney, and then you hire, if you're in that category, in your case will be reset, meaning that you'll be given another court date to give you time to hire your attorney. And that will be reset today. Now, the next category is for individuals who will be applying for a court-appointed attorney. If you're applying for a court-appointed attorney, and if you qualify, your attorney will be appointed today. And the last category is for individuals who like to waive their right to an attorney and represent themselves. Now, if you waive your right to an attorney, you represent yourself, you'll have an opportunity to talk to one of the prosecutors to see if you can work out a settlement on your case today. Okay, now, it's gonna take us a little time to pick the paperwork up from you, because once we pick it up, we're gonna make sure it's filled out properly. And then we're gonna put you in one of three categories. If you need help with filling out the paperwork, then our core personnel will be, including myself, will be, available to, our core personnel will be available to help with filling out the paper, including myself. Now, it may take a few minutes to go through all the paperwork a little times. If you need to use the restroom, there are two restrooms in the hallway. The men's restroom is in front of in front of County Court at law number 3, which is right next to it. And the women's restroom is on the opposite side of the hall, in front of the 172nd District Court. Now, you'll be allowed to go out in the hallways to use the restroom. Please come back into the courtroom. Do not leave the courthouse. If you leave the courthouse, and if your name is called and you leave the courthouse and you're not here, then your bond will be forfeited. A warrant will be issued for your arrest. You will be arrested. placed in Jefferson County Jail. And then, I'm sure you're gonna bond out of jail. And we'll have to go through this all over again. So, we're gonna try to get you in and out and get through your case as quickly as we can. Okay, now. On that first page, that's titled Judge's Explanation of Rights of Defense Without Attorney. At the top left, it states, State of Texas versus and blank, there's a line. Please print your name on that line. The reason why I say print it, because if your handwriting is like mine, sometimes I can't even read them. Okay, so just print it, so we'll have an opportunity to kind of figure out, who you are. Okay, now, we get ready to go through this test. Make sure that you, conduct yourself accordingly, you're still in court. And so, we'll have our court personnel to help you, including myself. So the court is in recess.
Make sure you complete your paperwork before you step out. If not, you're gonna prolong your stay with us. You want to finger everything.
Jefferson County Court Law #2 is back in session. The court is in session in cause number 25 CCC Aura 2190. Case is style of State of Texas versus Khalil M. Bradley Harris. Mr. Harris, is that your full name?
Yes, sir.
Okay, Mr. Bradley Harris, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
No,
Okay, Mr. Bradley Harris, you may put your hand down. How are you doing?
no, all right.
That's good. Now, Mr. Bradley Harris, you were represented in your case by your attorney, Attorney Buddy Reynolds. And Attorney Reynolds, how are you doing?
I'm doing well, Judge. Thank you.
That's good. And Mr. Reynolds, do you waive a record in Mr. Bradley Harris's case?
Still waiting.
And the state is represented in this case by Attorney Farrah Nixon. And Attorney Nixon, how are you doing?
I'm fine, Your Honor. How are you doing?
I'm doing fine. Thanks for asking. Now, Mr. Bradley Harris, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Khalil M. Bradley Harris, on or about August 11th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. Bradley Harris, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead guilty, not guilty, and no contest?
Yes.
Are you pleading guilty freely and voluntarily?
Right.
And are you pleading guilty because you are guilty?
Right.
Mr. Bradley Harris, I also have before me a document that is titled Misdemeanor Plea Admonishments. This document is on my tablet. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Sir.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked guilty. Did you place your initials on this document?
Sir.
On page 3 of this same document, there is a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Sir.
I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Bradley Harris, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Mr. Bradley Harris, are you a citizen of the United States?
Yes, sir.
State Law States Exhibit 1.
No objection, states one.
No objection. State's Exhibit Number 1 will be admitted. And Mr. Bradley Harris, your attorney, Mr. Reynolds, has advised and counseled you. Are you satisfied with his services?
Yes, sir.
And Mr. Reynolds, you've advised and counseled Mr. Bradley Harris. Is there any evidence that he is currently mentally incompetent to stand trial?
None to my knowledge.
Okay, Mr. Harris, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
Essential terms as follows: 264 days in county jail, time served, time actually served, taxed and retired, to run concurrent with any parole revocation and felony case.
Do we know the felony? Oh, she was supposed to put this on the.
I don't know what he's on, what case is on for.
Yeah, I don't know either. I mean, that I don't need to run a CC with that. We can run a CC with this.
Yeah.
Yeah, because, that felony parole is, that really,
I think they have to give him credit for it anyway.
oh, right.
That,
But they got a hold on, him, you're right. Yeah, they give him credit. Did, this is the felony case number. Here you go. Okay, this is, let's see, that's 264. Okay, Mr. Harris, the state is offering that you serve 264 days in Jefferson County Jail. However, you will not be required to serve any more time in the Jefferson County Jail because you will be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. And this case is running concurrent with the felony case, cause number 25 DCCR 1334. Okay. And Mr. Harris, do you understand the state's offer?
Yes, sir.
Do you think the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Harris, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Harris, you'll sit there next to the bailiff, follow her directions. Do you have the paperwork? They're waiting on it to print. Okay, just have a seat, and once it's printed, you're gonna follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to follow the bailiff, and you have a blessed day.
Yes, sir.
All right. And
Judge had one other case, I believe Judge Bradley, Judge West, has found him incompetent and they're gonna reset it for review.
I'm bon ton. If they said he was found incompetent.
Yes.
Okay, it's live. So, let me see if they put the date.
Oh, basically, we have today's, so you wanna just put it with whatever day the felony,
What you talking about the, what you talking about, bon ton?
bond time.
Yeah, because they're gonna be
Right.
waiting on bed.
Thank you.
I'll fax you. the sentence this
Yeah,
time.
thank you.
Okay,
Judge.
all right, thanks a lot.
Yeah, but she. Oh. Well, what else? No.
Judge, I can give you, do I need to hold on to those?
No, I could put it in upstat.
Well.
Oh, thanks. Perfect timing. Jefferson County Court at Law number 2 is back in session. Court is in session in 2 cases, cause numbers 26 CCCR 0596 and cause number 26 CCCR 0923. Both cases are South State of Texas versus Rachel L. Willis. Is that your full name?
Yes, sir.
Okay. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing?
I'm doing all right.
That's good. Now, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And Ms. Willis, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Okay, Ms. Willis, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Tom Burbank.
Okay.
Attorney Burbank will be given information to contact you, and you will be given information to contact him.
Yes, sir.
Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day.
You too.
All right, you're gonna have a seat in that first chair on the wall. Here you go. You go. Amarion Gates. Mr. Gates, your full name is Kamarion Gates?
No, sir.
How you pronounce it?
It's Kamarion. Marion Barclays Gates.
What's your middle name?
Barclays.
Varquise
Yes.
Gates? Okay. How are you doing?
I'm
I'm doing fine, thanks, Max. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes.
You may put your hand down. Now, I have before me, Mr. Gates, 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yeah.
And is this your signature on the line that's titled defendant?
Yes.
Are these your initials on the line that state you like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indians. Do you recognize this document?
Yes.
And on this next page, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes.
Mr. Gates, before you signed and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Yeah, Mr. Gates, I read your answers. You meet the eligibility requirements for the appointment of court-appointed attorney. An attorney that will be appointed to represent you in this case is John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. You're welcome. Just have a seat in it, Mr. Gates. Have a seat in that second, is there a second chair?
Yes.
He has something in his, you can sit at that table. Yeah, sit at that table. There you go. There you go.
Willis.
The term is. But, if you have any questions, have an explanation.
Jorge Adrian Magana. This case is, 287 days old. Mr. Magana, your full name is that, pronounce it Jorge?
Yeah, Jorge George.
Jorge Adrian Magana?
Yeah, yes, sir.
Okay. Would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You may put your hand down. How are you doing?
I'm fine.
That's good. Ms. Magana, I see here you're applying for a court-appointed attorney.
Yes, sir.
I have two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yeah,
And is this your signature on the line that's titled Defendant?
yes, sir.
Are these your initials on the line that state that you like to apply for court-appointed attorney?
Yeah, they are.
And also I have a document that's titled Jefferson County Affidavit of Indians. Do you recognize this document?
True.
On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yeah.
Now, Mr. Magana, before you signed and initialed these documents, did you read the documents?
Yeah,
And did you understand what you read?
yeah.
And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Magana, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you, in this case, Attorney Don Boudreaux. Attorney Boudreaux is currently in court. That's the gentleman right there. Mr. Boudreaux is you'll be given information on how to contact Mr. Boudreaux. And he will be given information on how to contact you. He may have time to talk to you this morning. Now, Mr. McGowan,
Yeah.
you can have a seat in that chair on at the table next to Mr. Boudreaux. Yeah. Here you are. If you want to talk to him, you can. Yeah, y'all can either go in the back room, or if y'all want to go out into the hallway. If you want to talk to him, if not, I mean, the case is gonna be reset to give you time to do that. Okay. No, no, I don't think so. Okay. This is cause number 26 CCCR 0090. Case is style, the state of Texas versus Danny Bruno Jr. Mr. Bruno, is that your full name? Mr. Bruno, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, you help you God? Mr. Bruno, you may put your hand down. How are you doing, Mr. Bruno? That's good. Now, Mr. Bruno, you have a right to have a record made. That is, you have a right to have a court reporter to type down everything that's being said in the courtroom. You have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter? Okay. Now, Mr. Bruno, once you place your hat on that table. Yeah, right there, that's good. Now, Mr. Bruno, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Danny Bruno Jr., on or about August 16th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of marijuana that had a weight less than 2 ounces. Mr. Bruno, do you understand what you've been charged with? And to this charge, Mr. Bruno, how do you plead guilty, not guilty, or no contest?
No.
Now, you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Bruno, I also have before me a document on my tablet that is titled misdemeanor plea admonishment. This document is also labeled as State's Exhibit number 1. Mr. Bruno, do you recognize this document? On page 2 of the same document, there are 2 sets of initials. First set of initials are on a line next to a box that's checked no contingent, which means no contest. You place your initials DB on this document. The second set of initials is below a paragraph that is titled Discovery Admonishment, and it is next to a they are next to a statement that states, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty or no contest if you place your initials in the second location. On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature? And on the next document that's titled Trial Court Certification, the defendant's right of appeal, you recognize this document. And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Good. Now, Mr. Bruno, before you sign and initial all these documents, okay, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And Mr. Bruno, I also have before me on paper 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state that you would like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document? And is this your signature on the line that's titled Defendant? Now, before you sign and administer these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Now, Mr. Bruno, are you a citizen of the United States?
State offer States Exhibit 1, Your Honor.
Okay, now, Mr. Bruno, I have before me State's Exhibit number 1. State's Exhibit number 1 is the first document that I showed you on this tablet. And this is the same document that has your initials in the 2 locations on page 2, and it has your signature up here on page 3. Is it all right for the state to use this document as evidence in your case? Okay, no objection. State's Exhibit number 1 will be admitted. Mr. Bruno, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Bruno, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
That'd be a fine of $400.
Okay, for costs. Okay, Mr. Bruno, the state is offering that you serve a fine, that you pay a fine of $400 plus court costs. And what's the court cost in this case? $337, which comes to a total of $737. Are you able to pay that?
Yes, sir.
Okay, now, Mr. Bruno, you understand the state's offer? You think the state's offer in your case is fair and just?
Yes.
Do you accept the state's offer? Mr. Bruno, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Bruno, just have a seat and wait for your name to be called. Okay? Okay.
Thank you. It's happy, Mr.
Walter Brown.
Yes, sir.
Oh. Oh, hold on. You ready on that? Hold on, wait up. We're gonna do the other ones. Okay. Okay, Jasmine Fontenot? Yeah, just have a seat. Okay. Mr. Fontenot, would you please come up? She got 2 days pregnant. Why would she have to fill out an affidavit? If she got 2 days? Ooh, no, that's a guy. You Jasmine Fontenot?
Yes.
Oh, okay. We'll find out.
I got mine.
No. It's not about your name. We was talking about.
No.
He's.
He said this is mom likes the smell of jazz.
Okay, I didn't. He said he had his idea.
It's all right, it's all right.
Yeah, yeah, let me see. Okay, where, okay. It said Jasmine, Fontenot. Okay, this is, cause number 26 CCCR 0536. Case is style of state of Texas versus Jasmine Fontenot. And Mr. Fontenot, is that your full name?
Yes.
Jasmine J. Fontenot, I see a J here. How are you doing, Mr. Fontenot?
All right.
That's good. Would you please raise your right hand? You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God. Mr. Fontenot, you may put your hand up. And Mr. Fontenot, the state is represented in this case by Attorney Fred Vernon. And Attorney Vernon, how are you doing?
I'm well, sir. How are you today?
I'm doing fine. Thanks for asking. Now, Mr. Fontenot, before we go forward, I need to inform you that you have a right to have a court reporter to dictate or type down everything that's being said in court. You also have a right to waive or give a right to have a court reporter. Do you waive or give up your right to have a court reporter?
Yes.
You do? Okay. Now, Mr. Fontenot, I also have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jasmine J. Fontenot, on or about January 1st of 2026, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Fontenot, do you understand what you've been charged with?
Yes.
And to this charge, Mr. Fontenot, how do you plead? Guilty, not guilty, no contest?
Guilty.
Now, you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yes.
Okay, Mr. Fontenot, I also have before me on my tablet a document that is titled misdemeanor plea admonishments. Do you recognize this document?
Yes.
On page 2 of this same document, there are 2 sets of initials. First set of initials are on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes.
Second set of initials are on a line next to a box that states, I do not request discovery in this case, and I waive my right to discovery, and I choose to enter a plea of guilty, no contest. Did you place your initials in the second location?
Yes.
On page 3 of the same document, there is a signature above the line that is titled defendant. Is this your signature?
Sir.
And on the next document, that is titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have another document on paper, or 2 documents on paper. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant? Or are these your initials on the line that state you like to apply, or that you like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Guilty Plea or Proceeding to Trial. You recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Fontenot, before you sign all of the documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Okay.
Mr. Fontenot, are you a citizen of the United States?
Yes, sir.
Your Honor, at this time, the state offers states exhibit 1.
Okay. Now, Mr. Fontenot, the state is offering states exhibit number 1 to be used as evidence against you in your case. State's exhibit number one is this first document that I showed you on the tablet. This is the same document that has your initials in these two locations on page 2, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objections. State's exhibit number 1 will be admitted. Mr. Fontenot, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Fontenot, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
Yes, Your Honor, we do, and the essential terms are as follows, 2 days and time served.
Credit for time, sir. Okay, what's the court cost? Two. Now, Mr. Fontenot, the state is offering that you serve 2 days in Jefferson County Jail, but you would not be required to serve any more time in Jefferson County Jail because you've already served 2 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court cost in this case is $287. You have 2 days credit that will go toward that, which is $200, and leaves a balance of $87. Are you able to pay the $87 balance?
Not today.
Okay, let me, we gotta give him a affidavit. You can, she's gonna give you an affidavit to fill out. He has this receipt. Hmm?
No, it's not, that's not quick.
That's his receipt. This doesn't have a seat. And then check to see how many days credit he has. She
You wanna
gonna,
have a seat to do this, Judge?
yeah, he can. You're gonna fill out that first page, that first portion at the bottom. It talks about income on the left-hand side, on the right-hand side, it talks about expenses. And once you at the bottom, once you finish filling that out, she'll have you to bring it back up.
Okay.
Yeah, you can sit right there. This is cause number 26 CCCR 0538. case is out of state of Texas versus Alfredo Kittler Jr. Mr. Kittler, is that your full name?
Yes, sir.
Mr. Kittler, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Mr. Kittler, you may put your hand down. How are you doing, Mr. Kittler?
sir.
That's good. Mr. Kittler, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, well, first of all, before we go any further, Mr. Kittler, you have a right to have a court reporter to dictate everything that's being said. You also have a right to waive or give up a right to have a court reporter. Do you waive or give up your right to have a court reporter? Okay, just have a seat. We got to get Sebastian to come in. Yeah. Just have a seat. We'll call you back up. Okay, he is Mr. Fondo. You finished with your paperwork? Okay, Mr. Fontenot, I have before me a document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Mr. Fontenot, the court is gonna find that you're indigent, and based on the finding of indigency, the balance of $87 in this case will be waived, which means you will not have to pay it. And that's pursuant to Article 42.15 of the Texas Code of Criminal Procedure. Okay. Now, Mr. Fontenot, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just,
Yes, sir.
and do you accept it?
Yes, sir.
Okay, Mr. Fontenot, I'll follow people are in agreement that you have entered into it. Say, Mr. Fontenot, just have a seat in that chair and wait for your name to be called. All right. Oh, that's right.
Judge,
Where did Killer go?
he said, no. I broke it down, he said.
Okay, now, Mr. Killer, you was previously sworn in. Initially, you said you wanted a court reporter. Now you're saying that you do not want a court reporter, right? You want to waive it, right? All right. Yeah, he decided. He wants to waive his right to court reporter. Okay, okay. Now, Mr. Kidler, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Alfredo Kidler Jr., on or about September 6th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offenses, driving with license suspended or invalid or with previous convictions, suspensions, or without financial responsibility. Mr. Kidler, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Kidler, how do you plead? Guilty, not guilty, or no contest? No contest?
Yes, sir.
Well, I don't know. Maybe she can find out. Mr. Kidler, I have, now how do you plead? Guilty, not guilty, no contest? No contest. Now, Mr. Kidler, I also have before me a document that is titled Judge's misdemeanor plea of minors, which is state's exhibit number 1. Do you recognize this document? On page 2 of this same document, there's 2 sets of initials. One set is on the line next to the box says check no contingent, which means no contest. Place your initials on this document. Second set of initials are on a line below a paragraph that is titled Discovery Admonishment, and it's next to a box, next to a statement rather, that reads, I do not request discovery in this case. I waive my right to discovery and choose to enter a plea of guilty in no contest. Did you place your initials on the second location? On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Enter Guilty Plea Proceeding Trial. You recognize this document? And is this your signature on the line that's titled Defendant? Now, Mr. Kidler, before you sign and initial all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Kidler, are you a citizen of the United States?
State offers state's exhibit 1.
Okay, now, Mr. Kidler, the state is offering state's exhibit number 1 to be used as evidence against you. State's exhibit number 1 is this first document that I showed you on the tablet. This is the same document that has your initials in these locations on page 2, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes.
No objections? State's exhibit number 1 will be admitted. Mr. Kidler, is there any evidence that you are currently mentally incompetent to stand trial? Mr. Kidler, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, Your Honor.
And what is that agreement?
The essential terms as follows: 6 months deferred adjudication, $300 fine, waived community service.
Okay, Mr. Kidler, the state is offering that you pay, let me see, what's the court cost in this case?
He has 2 days. Correct.
Oh, you
Sorry.
giving her 2 days credit?
Sorry.
Okay, now she's gonna have to do the, okay,
Sorry.
so you got 2 days credit. You're gonna have to put that on here. Okay, guys, 2 days credit. 7.
Yeah. This is.
Okay, Mr. Kidler. The state is offering that you serve 6 months deferred adjudicated probation. During the 6 month probationary period, you're required to pay a fine of $300 plus court costs of $287, which comes to a total of $587. You would have 2 days credit that would go toward that, which means that the fine and court cost is $387. You also be required to pay probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $118 a month. Are you able to pay the $118 each month? All right. You will not be required to perform community service. That will be waived. You will be required to adhere to the other standard terms and conditions of your probation. Mr. Kittler, do you understand the state's offer?
Yes.
Do you think the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes.
Okay, Mr. Kittler, I'll follow the plea bargaining agreement that you have entered into with the state. And Mr. Kittler, if you successfully complete this probationary period, this case will be dismissed, will not result in a conviction on your record, and you may qualify for a non-disclosure, or your record will be sealed to the general public. Mr. Kittler, you can talk to attorney about that. Now, Mr. Kittler, you're gonna have a seat in that chair and wait for your name to be called.
Thank you.
Okay? Bruno, is that Martinez? Danny, okay. Ricardo Lee Martinez. Mr. Martinez. Your full name is Ricardo Lee Martinez? Mr. Martinez, would you please raise your right hand? Mr. Martinez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Martinez, you may put your hand down. How are you doing, Mr. Martinez? Okay, now, that's good. Now, Mr. Martinez, the state is represented in this case by attorney Kenise Williams. Mr. Williams, how are you doing?
Very well, Your Honor. And how are you and your lovely staff?
Are we doing fine? Thanks for asking. Now, Mr. Martinez, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up the right to have a court reporter?
Yeah, I waive.
Okay. Now, Mr. Martinez, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Ricardo Lee Martinez, on or about July 3rd of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failure to identify a fugitive with intent to give false information. Mr. Martinez, do you understand what you have been charged with?
Yeah.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
I pleaded guilty.
Okay.
Yeah.
Now, Mr. Martinez, are you pleading guilty free? That's what you pled.
I wanted to change it to no contest,
Okay, if that's what you wanted,
but
no, you feel if that's what you want to do, he'll give that tablet to you.
yeah.
They never was corrected. Okay. Now, Ms. Martinez, are you pleading no contest? Well, first of all, how do you plead? No contest? And are you pleading no contest freely and voluntarily?
Freely.
And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means. Okay, now, Mr. Martinez, I also have before me on my tablet a document that's titled Misdemeanor Plea Admonishment. You recognize this document?
Mm.
On page 2 of the same document, there are 2 sets of initials. First set of initials on the line next to boxes checked no contingent, which means no contest. Did you place your initials on this document? On the next section, is titled Discovery Admonishment. There's a set of initials on the line that state, I do not request discovery in this case. I waive my right to discovery, and I choose to enter a plea of guilty and no contest. Did you place your initials in the second location as well?
Didn't want to discuss.
Oh, you didn't want it?
Yeah.
Okay, you said it at,
I
huh?
requested it, yeah, I requested it.
Okay. And on page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification to Defendant's Right of Appeal, do you recognize this document?
Yeah.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yeah.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yeah.
I also have a document on paper. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yeah.
And is this your signature on the line that's titled defendant?
Yeah.
And are these your initials on the line that states you'd like to waive your right to attorney represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yeah.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Martinez, before you've signed and initialed all of the documents that I'm showing you, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Martinez, are you a citizen of the United States?
Mhm.
State,
States Exhibit number 1, Your Honor.
okay, Mr. Martinez, the state is offering States Exhibit 1 to use as evidence against you. States Exhibit 1 is this first document on the tablet that you acknowledge. This is the same document that you initialed on page 2 in these 2 locations. And this is the same document that you signed on page 3. Is it all right for the state to use this document as evidence in your case?
I did, yeah.
Okay, so basically you're saying all of this stuff that you signed and initially, you're saying is true and correct, and so it's all right. That I'm actually is all right for the
Yeah.
state to use this as evidence. Okay, no objection. State's Exhibit number 1 will be admitted. Now, Mr. Martinez, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Mr. Martinez, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement in this case?
The essential terms are as follows, Judge. There would be 10 days in the Jefferson County Jail, credit for time served, time actually served, and all costs should be taxed and retired. Is that your correct understanding, Mr. Martinez?
Yes, sir.
Okay, Mr. Martinez, the state is offering that you serve 10 days in Jefferson County Jail. You will not have to serve any more time in the Jefferson County Jail because you've already served 10 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Martinez, do you understand the state's offer?
Yes, sir.
And do you think the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Martinez, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Martinez, you'll stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go and you have a blessed day.
All right, yes, sir.
Good luck to you, Mr. Martinez. So you're welcome.
Mr. Mr. Bruno, previously you were sworn in, is that correct? And you previously entered a plea of no contest to the charges of possession of marijuana. They had a weight less than 2 ounces. You acknowledge that you initialed the 2 locations on page 2 of State's Exhibit number 1, and you signed State's Exhibit. And you also signed page 3 of State's Exhibit 1, is that correct?
Yes.
And you also acknowledge that you signed the trial court certification of defendant's right of appeal. Is that correct?
Yes, sir.
And you also signed judge's explanation of rights to defendants without attorney in that document where you stated that you wanted to waive your right to attorney to represent yourself. That correct? And you signed a waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Is that correct? Okay. And so the state is amending its offer in this case. And state, would you please state that offer?
Would be $100 fine, you know.
Okay. Okay. So, Mr. Bruno? Oh, go ahead and change that. I'm gonna. Now that comes to, okay, the state is offering a fine of $100 plus court costs. The court cost in this case is $337. That's a total of $437. Okay. Are you able to pay that today?
No.
Okay, let me do this here. Does he have any time in jail?
He does not in our county, but he has claimed that he has been time in jail in Baytown, I believe, in Harris County. About 3 days, what he said. But we can't confirm that because it's not in our system.
Let's see. We could, sometimes the bondsman,
Yeah, I had it.
oh, you got some paperwork?
My bill, well.
What you got, you got that, hold on a minute. No, I don't need the number. I'm gonna go to your file. Sometimes they have the bond in the, well, they should have the bond in the file, not sometimes. That's a Bruno,
Send it over here.
right?
I have to send it
So
back.
he picked you up from there?
No, I ain't make it time.
No, he was bonded out over in
Okay.
Harris County. But if it's an out of county bond,
Yeah.
they sometimes on those out of county bonds, oh, here it is right here, out of county surety bond. Sometimes they have information on that. Said, okay. $1,500 signed on the 30th of March of 2026. Misdemeanor in status. They don't say. They don't accept. It's ASAP bill by twice in the amount. say it on it. God, well, we know one thing, he got one day because because he got a bond.
Process of elimination, one day.
Yeah, I mean, we know that much. Let me see, what is that? I certified that on this A&M or 3:30, whose name appears notified his name notice. That's on the 30th. That's us. Wow. Yeah, they don't. I don't. Looking for it. I'm looking to see. I know we had one out of county bond one time that had at the top, it said when the person went into jail and when they got out. But this is a different county, so they don't have that one on this here. Yeah, they don't have that on this here. And I'm looking at the bond. That's all I see. Let me see, get back out, let me get out of this. Surety bond. When was, it was received, when was it? Oh, that's when it was closed out. On the 7th. I don't see it. It was issued on the 30th, on the 13th of January. Return. Closed out. On the thing, yeah. I don't see it. Oh, I mean, I don't think I know for sure you just one day because she bonded out that day. I just can't verify how many days you in. Okay. Well, so we can I can give you that 1 day credit. Okay. Which means that it will be a balance of 338, 337. You understand that?
Yes.
So would you be able to pay that?
Oh, payment plan.
And now let me do this here. We can when would you be able to now because the payment is gonna have to be made because it's not
Probation.
a probation. We would probably have to have you to pay like a lump sum. We can, I can give you time to do that. Is what I'm saying, which is a payment plan. So because the county is not gonna take $100 here and that.
At the time that you give it to me, you need to hold them on.
Right. Now, how much, when would you be able to make the whole amount?
Next Friday.
Oh, okay. So,
You can for sure do 337 next Friday. All right.
okay, so we'll give him to next Friday. Yeah, the fine is $100. He has a day credit. So his balance will be, now make sure the court cost is 337. Because we don't, I mean, it's in the paperwork. So his balance will be 337. Okay. Okay. Okay, so that's what it'll be. It'll be. Okay. Now, do you understand the state's offer and the findings,
Yes.
in this case? Okay. Just have a seat. Once she finishes the paperwork, she'll call you back up.
Say it one more time. I ain't hearing you.
Okay. Okay. This is cause number 25 CCCR 2726. Case is filed in the state of Texas versus Walter D. Brown. Mr. Brown, is that your full name?
Yes, sir.
Mr. Brown, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Mr. Brown, you may put your hand down. How are you doing, Mr. Brown?
Fine.
That's good. Yeah, dated. And Mr. Brown, you represented in your case by your Attorney John Cole. Attorney Cole, how are you doing?
Great judge.
That's good. State is represented in this case by Attorney Samuel Masradian. And Attorney Masradian, how are you doing?
Doing well, Judge. Thank you.
That's good. Now, Mr. Brown, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Walter D. Brown, on or about October 4th, 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault, bodily injury to a family member. Mr. Brown, do you understand what you have been charged with? And to this charge, Mr. Brown, how do you plead guilty, not guilty, or no contest?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you, okay, on this document, it has no contest. Now, you're pleading no contest or guilty?
Okay.
Now, you're pleading no contest freely and voluntarily?
Please.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Brown, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on page 2. The initials are WB. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? And I also have a document that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled Defendant? Now, Mr. Brown, before you signed and initialed these documents, did your attorney go over these documents with you? And did you understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Mr. Brown, are you a citizen of the United States?
Yes, sir.
State offers states.
No objection. State's Exhibit Number 1 will be admitted. And Mr. Cole, you advised and counseled Mr. Brown. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Brown, your attorney, Mr. Cole, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Brown, now, Mr. Cole,
Yes.
is there any evidence that your client is mentally incompetent to stand trial?
No, Your Honor.
Mr. Brown, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in Mr. Brown's case?
We do, Your Honor.
And what is the agreement?
It'd be 14 months deferred adjudication probation, $500 fine, 80 hours community service, completion of an anger management class, and that there be no threatening or harassing statements made to the complaining witness, in this case, Waltiana Brown, throughout the duration of the deferred adjudication.
Okay. What's the, it's 80 hours of community service.
Yes, Your Honor.
Mr. Mr. Cole was appointed. Okay. Okay, this case, we had a day of trial. Let me do this here. That's 100. Okay, yes. 100. I'm just guessing. What's the court cost? 382. Okay. Okay. Let me check this. What is? Now, Mr. Brown, the state is offering that you serve 14 months deferred adjudicated probation. During the 14-month probationary period, you'll be required to pay a fine of $500 plus court costs of $382. You'll also be required to pay a crime victims center, family violence center, $100 fee. You're required to pay a probation fee of $6 a month, urinalysis fee, $15 a month, and a reimbursement fee. You'll also be required to pay a reimbursement fee of $15. You're also required to reimburse Jefferson County Court upon attorney's fees of $1,150. Your total monthly installments that you will be required to pay in this case is, that's the same thing. Yeah. Oh, it's gonna go up $1. You'll be required to pay, $246 a month. Are you able to pay that? You are? All right. You're also required to perform 80 hours of community service. You're required to attend and complete an anger management class. And you cannot communicate to the victim in this case, while,
No, it's not no
Well,
contact order.
no, I hadn't finished.
Okay.
Say, I didn't say no contact. I said you're not required to communicate to Waltiana Brown in a threatening or harassing manner. And you're also required to adhere to the other standard terms and conditions of this probation. Now, Mr. Brown, do you understand the state's offer?
Yeah.
Do you think the state's offer in this case is fair and just?
Yeah.
And do you accept the state's offer?
Yes, sir.
Mr. Brown, I will accept the plea bargaining agreement that you have entered into with the state. Mr. Brown, you'll stand next to the bailiff, follow her directions. Once you're finished following her directions, you'll be free to go. And you have a blessed day. And Mr. Cole, you're free to go and you have a blessed day as well. Yeah. This will conclude the calling of the court's docket on the day's date, May 19, 2026 in County Court at Law Number 2. Judge Terrence Holmes presiding. Everyone, please have a blessed day. Prosecutors, you're excused.